Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our episode number 4 in the series Indian Polity Current Affairs for Prelims 2025. So this episode 4 is a continuation of episode 3. So in the previous episode, we have started the topic of legislature. We have covered few topics and we continue with the more topics and we'll cover the legislature. As I already said, the objective of this current affairs series with regard to the Indian polity is to help the students who have already watched the Indian polity series, and of course students who may be preparing for prelims 2025 also. Whether they have seen the series or not, if they have already prepared and if they are appearing for the prelims 2025, this is a very good way that you can revise the most important topics, because objective is to restrict to very few relevant topics. So therefore, your burden can be little reduced. And about the students who may be appearing for 2026, can they watch this? Yes, they can also watch it. But as I already said, you can watch it after you do the fundamental course. So then it will make sense. Okay. So with that, I'll get into the topic. The first topic that I want to discuss today is the Supreme Court to look into the use of money bills to pass laws. Of late, one of the allegations against the government for the last few years is sometimes if the government is not having the majority to get the bill passed in both the houses of the parliament. You know that when a bill is introduced, it can be introduced mostly in either houses. I'm talking about generally. And then it has to get passed in both the houses of the parliament. In fact, if it is an ordinary bill, then the bill can be introduced in either houses, and after it is introduced in either houses, it has to be passed in both the houses separately by simple majority, or sometimes there can be a joint sitting also. So therefore, when it comes to an ordinary bill, both the houses of the parliament almost have equal powers, except unless and until a joint sitting is convened. But however, if you look into the provisions of a money bill, there is an exception. So what is the provision of a money bill? The procedure for a money bill is little different. That in case of a money bill, the Rajya Sabha does not have much powers. In fact, the maximum powers in the hands of Rajya Sabha when it comes to a money bill is that they can delay the passage of the bill by 14 days, which we'll subsequently see as we'll proceed. So one of the allegations that has been coming against the government is the government where they do not have the majority in the Rajya Sabha. Under such a circumstances, in order to silence the Rajya Sabha, the bill is introduced as a money bill. So is it possible to introduce any bill as a money bill? What are the provisions in the constitution with regard to a money bill? What is the procedure for a money bill? What are the relevant constitutional provisions in the articles? Because this is an area at least 8 times a question have come in the last 10 years. So therefore, very, very important topic. So please pay an attention. I'll discuss all those things. But what was the current issue? Although the current issue is not very important when it comes to the examination point of view, but because of the current issue, the questions may come from the constitutional provision. But what is the current issue? The allegation today against the government is many amendments to the bills, like the amendments to the Prevention of Money Laundering Act, the amendments to the Foreign Contribution Regulation Act, the passing of Finance Act 2017, the passing of Aadhaar Act in 2016. Now all these bills has been passed as a money bill. And what is the allegation against passing these bills as a money bill? The allegation is, or in fact the matters have gone to the court also, is that these bills does not fall under the ambit of what is called as a money bill. And when they do not fall under the ambit of what is called as a money bill, then is it constitutional to pass a bill which is not a money bill, and is it possible to pass them as a money bill? If that is the case, is it not amounting to violation of the constitution? That is exactly the question the Supreme Court has to decide. While the Supreme Court has not declared on the constitutional validity, the Supreme Court has said that to look into these matters, will establish a 7-judge constitutional bench. And they will look into the larger question of whether these bills, the bills that I have talked about, will fall within the ambit of what is called as a money bill or not. And last year again this matter was mentioned in front of then Chief Justice of India, Mr. D.Y. Chandrachud, Chief Justice D.Y. Chandrachud. And he said very soon he'll appoint a 7-judge constitutional bench. But I think the bench is yet to be constituted. But anyways, so in this context, it has come in the newspaper. So therefore, let us try to understand all the constitutional dimensions which is basically related to what is called as a money bill. So what is the relevant article when it comes to a money bill? So very, very important. Sometimes they can ask you the articles also. So what is the relevant article when you talk of the money bill? It is Article 110 in the Constitution. In fact, Article 110 Class 1, Subclass A to Subclass G, it deals with certain subject matters. And if any bill contains only these subject matters, then such a bill can be considered to be what is called as a money bill. But the most important point here is that these bills should contain only these subject matters, not any of the other subject matters. What are those subject matters predominantly related to? These subject matters majorly related to what is called as taxation matters. They relate to what is called as the appropriation of money from the Consolidated Fund of India, and they relate to what is called as the borrowing classes of the government, which deals with the borrowing powers of the government, which also deals with the receipt of money on account of the Consolidated Fund or the public accounts. So these are all the subject matters which is mentioned in Article 110 Class 1 Subclass A to Subclass G. So in fact, there are 6 subject matters which is specifically mentioned. But apart from the 6 subject matters, there is one more subject matter C, not G, Article 110 Class 1 Subclass G. So what is this saying? This is saying that if any matter which is incidental to any of the other matters, incidental to any of the other matters which is mentioned from Article 110 Class 1 Subclass A to Subclass F. So this G is saying if any matter which is incidental to any of the other subject matter which is mentioned in these provisions, then also it can be considered to be what is called as a money bill. So therefore, if you look into Article 101 Class 1 Subclass G, it does not specifically say any subject matter, but if any subject matter which is incidental to these subject matters, then in that particular case they can also considered to be a money bill. And that is why this Article Class 1 Subclass G is also considered to be what is called as a supporting clause. It does not have any specific matter, but it is a supporting clause. Or in other words, if it may contain any subject matter, and if that subject matter is a supplementary matter which is related to a primary subject matter which is mentioned from Article 110 Class 1 Subclass A to Subclass F, then still such subject matter would be considered to be what is called as a money bill. But however, the supplementary matter or the matter incidental should be completely integrated with the main matter which is given in Article 100 Class 1 Subclass A to Subclass F. For example, Article 100, with an example it will be quite clear to you. Article 110 Class 1 Subclass A, which deals with what is called as taxation. Suppose now let us assume there is a bill that is introduced in the parliament that is dealing with taxation. Can that be considered to be a money bill? Yes, it may be a money bill because it is dealing with taxation. But there is a provision in this particular bill which is also talking about fines or penalties in case of non-payment of taxes. While collecting tax is an item in the money bill, but fines and penalties are not mentioned directly in Article 110 Class 1 Subclass A. But however, what is Article 110 Class 1 Subclass G is saying that if any subject matter which is incidental to the primary matters, or any subject matter which is integral to the primary matters, or any matter which is mentioned from A to F which has a relation to what is mentioned in G, then also it can be considered to be a money bill. So in order to collect taxes, if a bill is introduced and if that provision is, that bill is also providing for the provision of collecting fines and penalties, because those fines and penalties are very, very important to enforce this particular act, that is to collect taxes. So therefore, this fines and penalties would be considered to be an incidental matter or a supplemental matter which is connected to the main matter. So therefore, this can also be considered to be what is called as a money bill. So therefore, try to understand that what is considered to be a money bill if it is falling with subject matters mentioned in Article 100 Class 1 Subclass A to Subclass F, 6 matters, and then if any matter which is incidental to any of these 6 matters, then also it can be declared to be what is called as a money bill. So this is a basic understanding you should have with regard to a money bill. So therefore, when the Supreme Court tomorrow establishes a constitutional bench, so probably this is the yardstick parameter they are going to apply to determine whether a particular bill is considered to be a money bill or not. Further, under the Constitution, we should also remember Article 110 Class 3, which gives a power to the Speaker to certify a particular bill as a money bill. So who is authority to certify a particular bill as a money bill? It is a Speaker. So it's very important. So you'll have to remember all these provisions, and once a bill is certified as a money bill by the Speaker and when the bill goes to the Rajya Sabha, the maximum power in the hands of Rajya Sabha is that they can delay the passage of the bill by 14 days. So they do not have any of the other power apart from this. So the Rajya Sabha can maximum delay what? Delay it by 14 days. The Rajya Sabha can either accept the bill or the Rajya Sabha can suggest certain amendments within 14 days to the bill, suggest amendments within 14 days, but these suggestions are not binding upon the Lok Sabha, and the Rajya Sabha anyways cannot reject a money bill. So maximum power that they have got is they can delay it by what is called as 14 days, and in fact exactly this is the allegation that is made against the government, that the government is trying to misuse its power through the office of the speaker by certifying the ordinary bills as a money bill. Anyways, this is only merely an allegation. It is for the Supreme Court of India to decide whether this power has been abused or not by scrutinizing this particular matter in what is called as a larger constitutional bench comprising of 7 judges. And apart from that, what may also be relevant for you is the procedure with regard to a money bill. Last year there was a question with regard to procedure for money bill, and which article talks about the procedure for a money bill, because we know different types of bills in the parliament has got different procedures. So what is the article that is related to procedure in case of a money bill? It is article 109 that talks about what is called as a procedure for a money bill. Two important things that you have to remember as to how this bill is different from that of the other bills. When it comes to a procedure for a money bill, the first thing that you have to understand is such a bill can be introduced only in the Lok Sabha, and such a bill can be introduced only with a prior recommendation of the president. So these two things are different in comparison to that of an ordinary bill. While an ordinary bill can be introduced in either houses and there is no need for prior recommendation of the president, but whereas in case of a money bill, it can be introduced only with a prior recommendation of the president and it can be introduced only in the Lok Sabha. So try to remember this. And then when it goes to the president for the assent, the president can give the assent or he can withhold the assent, but he cannot send it for reconsideration. Alright, so these are all some things that probably you can keep it in your mind. Very, very important, and every year UPSC is asking a question from a money bill. So what are the areas they can ask? They can ask about the subject matter, article 110. They can talk about the procedure. They can ask about what is the maximum power in the hands of the Rajya Sabha. They can ask question about whose authority to decide a particular bill, certify a bill as a money bill. So these are all the important areas. So probably you'll have to keep it in your mind. Alright, so come to the next important topic. So this topic is related to what is called as a parliamentary committee, and this parliamentary committee is nothing but the Public Accounts Committee. Now why this was in news? This was in the news in the context that the Public Accounts Committee has declared that they are going to scrutinize the various regulatory bodies in our country. And in fact, you know that the Public Accounts Committee is one of the most influential parliamentary committee. And to be very specific, the Public Accounts Committee is one of the important financial committees in the parliament. And the main objective is to ensure the financial accountability of the government to the legislature. So that's what is the Public Accounts Committee. And recently the Public Accounts Committee said that they are going to review the functioning of the regulatory bodies. There are various regulatory bodies in our country. And the PAC said they are going to, without naming a particular regulatory body, they said that they are going to review a number of regulatory bodies, including the Security Exchange Board of India. The Security Exchange Board of India is a statutory body, and this statutory body today regulates the capital markets in our country. In fact, why this becomes very important, because there was also a report which was released by an organization called as Heidenberg, where they have made some allegation against the way that how the stock prices in India are manipulated by SEBI. But it is again a report, so that there's nothing which is conclusive about it. But subsequent to this, the PAC came and said that they are going to review the regulatory bodies in our country. So in that particular context, there is a possibility that they can ask you questions from what is called as a Public Accounts Committee. So you should be aware of what is this Public Accounts Committee. So we should be aware of the basic composition about the Public Accounts Committee and the functions of the Public Accounts Committee. So these are all the important areas, and in fact the most important thing which is also reported in the newspaper is how the Public Accounts Committee is very unique in comparison to that of the other committees. So therefore we should be aware of this as well. So let us try to understand all those things. So first, if you see the Public Accounts Committee, one significance of the Public Accounts Committee, it is one of the oldest parliamentary committee in our history. So when this Public Accounts Committee has had its genesis way back in the year 1921. So try to remember this. So as a part of the financial committees, it was established way back in 1921 based on the recommendation of the Montagu-Chelmsford reforms. Montagu-Chelmsford reforms of 1919. So based on this, the financial committee, and one such important financial committee, or one of the first financial committee, is the Public Accounts Committee. So therefore, the genesis is where 1921, which report Montagu-Chelmsford reforms. And right now, if you see the composition of the Public Accounts Committee, it has got 22 members, and all the 22 members are elected, and they are all elected based on proportional representation. So what does it mean by proportional representation? That means the number of members in this particular committee will be proportionate to the representation of MPs from different parties. So therefore, today if you see which party has got highest representation in the Public Accounts Committee, it is BJP, because they have got largest members in the Lok Sabha. So it is based on proportionate representation. All the members are elected. And out of this 22 members, 15 members are from Lok Sabha and 7 members are from Rajya Sabha. So therefore, the total is 22 members. And the chairman of this particular member is usually a member from the opposition party. This is again very important. Usually, a member of the opposition party is appointed as the chairman, and that is also followed as a parliamentary conventional practice. There is nothing in the constitution about this. There is nothing in the rules of the house as about this. It's only a conventional practice. So presently it is Mr. Venugopal, K.C. Venugopal of the Congress party is the chairman of the Public Accounts Committee. In fact, Mr. K.C. Venugopal has summoned the SEBI chief to appear in front of them, which he has failed to appear. That's a different story. But this is something, the development that has happened with regard to all those things. So therefore, this becomes very important for your examination. And before I complete the Public Accounts Committee, what is the primary function they are supposed to perform in our country? The primary function is that they scrutinize. What do they scrutinize? They scrutinize the report of the CAG. So the CAG does the audit of the government revenue and expenditure. So they does the audit of both the revenue as well as the expenditure. So both this revenue and the expenditure report will be submitted by the CAG to the president. And then the president will in turn submit it to the parliament. And in the parliament, when the president submits, these report will be audited by the Public Accounts Committee. So that's a primary function. Of course, apart from that, they have the other functions also. So how the Public Accounts Committee is unique in terms of its functioning. So let us try to understand that as well. And in fact, this came very elaborately in the newspaper. So therefore, whenever UPSC asks a question, they may ask something conventional, something current facts also. So we should be aware of the current facts as well. So how the PAC is different from the other committees in the parliament? It is the first and the original parliamentary committee. So try to remember this, which is the first committee to be established. In fact, to be a financial committee is the Public Accounts Committee way back in 1921. And then it has far greater ambit than any department related standing committees. That means far greater ambit means far greater functions and far greater powers probably in relation to any of the other standing committees in the parliament. It is the PAC. So the most important financial committee you can say is the Public Accounts Committee. That is what they are trying to mean. Not only the financial committee, in general, any standing committee, the most important committee is the Public Accounts Committee. And then the PAC is also empowered to call any person in connection with the investigation. That means they have the power to summon anyone in case of investigation. Using this power, the chairman of the Public Accounts Committee has summoned the SEBI chief. So this is also an unique feature of the Public Accounts Committee. So therefore, please try to remember their composition, who would be the chairman, how they are they elected or they nominated. So these are all in areas, and what is the genesis of the Public Accounts Committee, when it was initially appointed. So any of these things can be asked in the examination. All right. So with that, I'll move to the next topic, that is related to the Anglo-Indians. Now, what is the news in the current affairs related to the Anglo-Indians? The news that is related to the Anglo-Indians today is that there is something that has significant happened by the 104th Constitutional Amendment Act 2020, if I am not making a mistake, with regard to the year. The amendment is not a question. So what is the change that has happened with regard to the 104th Constitutional Amendment Act is the Constitution was amended by the Parliament, and they have done it with a nomination of the Anglo-Indian members in the Lok Sabha and the Legislative Assembly. So after the 104th Constitutional Amendment Act, there was no provision to nominate an Anglo-Indian member in the Lok Sabha and also in the State Legislative Assembly. So was there a provision earlier? Yes. As per the original constitution, the President of India has a power to nominate 2 members from the Anglo-Indian community in the Lok Sabha, and the governor of each and every state had the power to nominate 1 member from the Anglo-Indian community in the Legislative Assembly of the concerned state. In fact, this provision was supposed to remain only for the first 10 years period, because if they feel that the representation of the Anglo-Indian is inadequate, so then the president and the governors can nominate. But however, it is supposed to be there for only 10 years. But however, the constitution was subsequently amended every 10 years, and an extension was given for another 10 years. And in this way, the extension continued till 2020. But in 2020, when the constitution was amended, they did not give any extension further to the nomination of the Anglo-Indian members to the Lok Sabha and the Legislative Assembly. So therefore, in that context, this current development has happened. And what is the current development? Today, the Anglo-Indian community has protested, a form of protest, a constitutional protest, that they urge the center that the previous position has to be restored, that they need representation or they have to be nominated in the Lok Sabha as well as in the legislative assemblies. And apart from that, they are also to be recognized as a minority community. So separate minority community. Although they belong to the Christian community, they have to be separately identified as a minority community. This is the demand that has been made by the Anglo-Indians. Now, in that context, this news has come in the newspaper. So therefore, it also becomes very, very important. So first and foremost thing is, what is the definition of Anglo-Indian? So you don't have to remember the definition of Anglo-Indian if you want to remember, but it's not very important. UPSC is not going to ask you to identify the definition of Anglo-Indian. But the important thing that you should know is whether this definition is given in the constitution or not. Yes, of course, this definition is given in the constitution, and it is also reported in the newspaper. So therefore, it becomes very important where exactly it is defined. First, you should know it is defined, and where it is defined in Article 366 Clause 2, which basically gives a definition for number of other provisions also. So is it defined in the constitution? Yes, and it is defined under Article 362 Clause 2 of the constitution. So please remember that the Anglo-Indians are defined in the constitution. And what is a change that has happened by the 104th Constitutional Amendment Act? The provision for nomination has been done away with, which can be done by the president in case of the Lok Sabha, and which can be done by the governor in case of the legislative assemblies. 2 members from the Anglo-Indian community can be nominated by the president in the Lok Sabha. 1 person from the Anglo-Indian community can be nominated by the governor in the legislative assembly of the concerned state, provided if the president and the governor feels that their representation is not adequate. So this was the original provision, but this provision is supposed to continue only for the first 10 years, that is till 1960. But before 1960, the constitution was amended and it was extended for another 10 years. And subsequently, every 10 years it was amended and it was extended till 2020. But in the 104th Constitutional Amendment Act 2020, this amendment has done away with a provision for the Anglo-Indian nomination. So therefore, there is no provision for Anglo-Indian nomination. And which amendment? 104th Constitutional Amendment Act. So what are the questions that can come from this area? Is an Anglo-Indian defined in the constitution? Maybe they will not go to the extent of the articles, but you should know whether it is defined and what was the privilege that they were exercising and what has been done away by the 104th Constitutional Amendment Act. So all those things becomes very important. And what is the article that allowed for the nomination of Anglo-Indian members? It is Article 331 in case of Lok Sabha and Article 333 in case of the state legislature. Okay, so these are all the information, probably you can keep it in your mind. So please come to the next current affairs. What is the issue around delimitation? Very, very important topic. I would say that this year definitely there may be a question from delimitation. So please try to learn carefully. In number of contexts, this delimitation is coming in the newspaper again and again. So let me tell you what are the contexts in which the news is coming. One context in which the news is coming is that the southern states are very much opposed to the delimitation exercise. Not in general they are opposed, but their apprehension is that the delimitation exercise might reduce the number of seats to the southern states. And in fact, if at all the delimitation is carried out, it has to be carried out in such a way that their interest is not harmed or affected. So this is one area where the delimitation exercise is important. In fact, to that extent, recently a conclave was held in the southern states, which was headed by the Chief Minister of Tamil Nadu, which was attended by a number of other Chief Ministers in the southern states. There are representation from the state of Kerala, Andhra, Telangana, Karnataka. So all the Chief Ministers or their representatives have come and they met. So the idea is that they wanted to protect their interest so that the number of seats allocated to the Lok Sabha does not get reduced. So what is delimitation and what kind of relation does the delimitation has got to the number of seats to the Lok Sabha in these states? It's what's the question that they have to understand. So this is in one context. There's of course another context in which it is also discussed that why the delimitation is very important with regard to implementation of what is called as the reservation to the women. The 106th Constitutional Amendment Act in 2023 has allocated 1/3 of the seats in the Lok Sabha and legislative assemblies to women. But however, it is yet to be implemented. It is yet to be implemented, and one of the reasons is the delimitation has not happened. So in that context also, the delimitation is coming again and again in the newspaper. So therefore, we'll try to understand first of all what is this larger or what is this delimitation in the first place, and what are the constitutional provisions that are surrounding to what is called as delimitation. Now, what does it mean by delimitation? So delimitation means basically allocating number of seats from each and every state to the Lok Sabha elections as well as to the legislative assembly elections. So for example, if Uttar Pradesh is there, somebody has to decide how many seats will be there or will be given to the state of Uttar Pradesh in the Lok Sabha. How many seats will be there in Uttar Pradesh in the legislative assembly elections? So somebody has to decide this. The process of deciding the number of seats is what is called as delimitation. So delimitation is not only this. So delimitation also involves other things. So primarily it is deciding the number of seats. Apart from deciding the number of seats, then delimitation is also about drawing the boundaries of these constituencies. Now say for example, if Uttar Pradesh is said to have 80 seats, then the entire territory of Uttar Pradesh has to be divided into 80 smaller units, constituencies, and every constituency should have a territory, and based on which the Election Commission of India will carry out the election. They will prepare the electoral roll. So therefore, delimitation means first deciding the number of seats, and based on the number of seats, drawing boundaries for each and every constituency. And in addition to that, delimitation would also mean reserving of seats or reserving of constituencies to the scheduled caste and scheduled tribe in proportion to the population. So after deciding the number of seats, total number of seats, after deciding or drawing the boundaries of each and every constituency, certain constituencies to Lok Sabha and to the legislative assembly shall also be reserved to the scheduled caste community and the scheduled tribe community. And how it shall be done? It shall be done in proportion to the population of that particular community in that particular state. So all the three jobs are to be done by what is called as delimitation commission. And in general, all these things are to be done in proportion to population. Now, who shall do all those things? So for that, the question for this particular question, who shall do this delimitation process? Who shall be entrusted up with this responsibility of carrying out all the three things? So for that question, we will have to look into Article 82 and Article 170 in the Constitution. So if you look into Article 82 and Article 170 in the Constitution, it says that delimitation exercise shall be carried out by a commission or by a body which shall be established by an act of parliament. So the parliament shall make a law, and by that law they shall establish a body, and according to which all these delimitations shall be carried out in proportion to the population. According to the provisions of these articles, the parliament has enacted what is called as the Delimitation Act. Delimitation Act. And as per the Delimitation Act, the first one was passed in 1952. As per the Delimitation Act, the Delimitation Commission was established. And today, who is doing all these things is the Delimitation Commission. So this Delimitation Commission is a statutory body which is entrusted with all these three responsibilities. And the Delimitation Commission is an independent authority which will perform all these functions. So this is the basic thing that you'll have to keep in your mind. But however, I said the Delimitation Commission will do all these jobs, all the three things that I have discussed based on the population. And what is the population based on which they have to do all those things? It says that whenever the delimitation is carried out, it shall be on the basis of latest population. That is what the Constitution says. Whenever the delimitation is carrying out, what is the latest population? Latest population means we know the population based on the latest census. So the latest census shall be taken into account. That is what the original constitution says. But however, this provision was amended subsequently by Prime Minister Indira Gandhi by the 42nd Constitutional Amendment Act. And she said by the 42nd Constitutional Amendment Act in 1976, and she frees the census to be 1971 census, and the 1971 census shall be used till the year 2000. For determining the total number of seats, while the delimitation has three functions, but to determine the total number of seats, what would be the census that is to be used? Whenever the delimitation is carried out till the year 2000, it will be based on 1971 census. But again, the provision was amended by the 84th Constitutional Amendment Act in the year 2000, and they fixed the 1971 census till the first census is published after the year 2026. That means whenever the first census will be published after the year 2026, so we have not entered into the year 2026, but whenever the first census will be published after the year 2026, till that point of time, any delimitation exercise that will be carried out in our country, which census shall be taken into account? It is the 1971 census. So therefore, for the latest election, which census was taken into account? It was a 1971 census when it comes to the total number of seats. Therefore, you can understand that after 1976, there was no change in the number of seats when it comes to the Lok Sabha elections, because every time it is based on the 1971 census. So this is primarily what you'll have to keep it in your mind. So the delimitation body, how much times they have been brought into our country? So how many times the delimitation commission has been established? It has been established 4 times in our country. So 1952 was the first time, then 1963 the second time, 1973 the third time, and 2002 the fourth time. In all the 3 cases, they have done all the 3 functions. So 1952 based on 1951 census, that was latest census. 1963 based on 1961 census. 1973 based on 1971 census. The 1971 census was used for all the purpose. 1951 census was used for all the 3 purpose. 1963 census were used for all the 3 purpose. In 1973, that is in 1971. In 1973, when the delimitation was established, they used 1971 census for determining the total number of seats, and also for drawing the boundaries of those constituencies, and also for allocating, reserving seats for the scheduled caste and scheduled tribe. But the last delimitation commission was established in 2002, which is based on 2001 census, but this 2001 census is only for drawing the boundaries, because it is not, 2001 census is not used for allocating the total number of seats, because the total number of seats will be based on 1971 census, and it will be based on 1971 census till the year the first census is published after 2026. So therefore, this 2001 census is only used for drawing the boundaries and also for reserving seats for scheduled caste and scheduled tribes. Seats for scheduled caste and scheduled tribes. But the total number of seats is still based on what is the 1971 census. So even today, the total number of seats is based on 1971 census, but the boundaries shall be on the basis of 2001 census, and the reserving of seats to the scheduled caste and scheduled tribe shall be on the basis of 2001 census. That's basically what you'll have to understand in your mind. Now the question is why, as per the news reports, you can understand why this 1971 census was fixed. This 1971 census was fixed to be the census to be used in order to provide a level playing field to all the states, so that the states are not in a disadvantaged position even if they implemented measures to reduce the population. Because post 1976, one of the major agenda of the central government was population control. So in that regard, many policy guidelines was given, and many states were implementing the population reduction program or the population control program. But because they have reduced the population, they should not be in a disadvantaged position, and that's the reason as to why the census was fixed based on 1971 census. Now the same view is taken by the southern states, saying that we have followed the directions which is given by the center, reduce the population. Are we going to be penalized just because you reduce the population and then you will reduce the number of seats? So therefore, any delimitation that is happening should be done in a very fair manner without affecting our seats. So that's the concern of the southern states. Anyways, we are not sure which way the delimitation is going to happen, but for which first we need to have the census after 2026, then the delimitation will happen. But anyways, there are apprehensions already from the southern states. So this is the reason as to why many of the southern states have raised their apprehension to the Home Ministry of India. But now the latest question which is also discussed in the newspaper is why the census and the delimitation is very important with regard to the implementation of the Women's Reservation Act, that is the 106th Constitutional Amendment Act. If you read the newspaper reports, the 106th Constitutional Amendment Act states that 33% of the seats, not less than 33% of the seats, shall be reserved to the women, both in case of Lok Sabha as well as in the state legislative assemblies. But however, when this provision shall get implemented is only when this act is getting notified, only when this act is published in the official gazette, not just when it is published in the official gazette. After it is published in the official gazette, the first census should be published, and based on the first census, a delimitation exercise has to happen, and only then you can implement this reservation to women. So therefore, to implement the reservation for the women, it becomes mandatory to carry out the census after it is notified, after this act is notified, and based on that particular census, a delimitation exercise is carried out. Only when both the things are completed, then only there is a possibility of implementing the women reservation, otherwise it is not possible. So therefore, the publishing of census and thereupon a delimitation exercise becomes mandatory to implement the 106th Constitutional Amendment Act, that is the Women Reservation Act. So this is also reported in the newspaper, and to that extent it becomes very important. So what type of questions can be asked from this particular area? A lot of questions can be asked. They can ask you about what is a delimitation commission. It's a statutory body established by an act of parliament. I think last year there was a question, how many times a delimitation commission has been established? 4 times. Very simple answer. And they can ask you about number of other things. What are the functions of delimitation commission? What is the population that they use? Why this population? What was the reason the population or the census was fixed to be 1971 census? What is the significance between the census delimitation and the Women Reservation Act? So any of these things can be asked in the examination. So please be clear about all those things. Alright, so with that we are coming to the final topic, again reported in the newspaper many times, motion of thanks. Now what exactly is this motion of thanks? In which context it was reported in the newspaper? In fact, the first and foremost thing that you'll have to understand is there is no mention of this particular word motion of thanks in the Constitution. The close relation to the motion of thanks is only Article 87 of the Constitution. I'll just discuss about this. Article 87 of the Constitution says that the President shall make a special address in couple of occasions. So what are the occasions that the President shall make a special address to the both houses of the Parliament? One is during the first session after the Lok Sabha election is over, and also during the first session every year. The first session every year is a budget session. The first session after the Lok Sabha election is when the Lok Sabha is brought into session and when the government is formed. That's the first session after the general election. In both the cases, as per Article 87 of the Constitution, the President makes what is called as a special address. So normally why it is called a special address? Because this address is prepared by the government and it is delivered by the President on behalf of the government. So normally it is the agenda of the government. After the general election is over, there is some agenda to the government and the government wanted to convey this to the other members of the Parliament through the President. And during the budget session also, the special address is made by the President, which is again prepared by the government, which is basically a report card of the government for the previous year. So in both the cases, the address is prepared by the government, presented by the President. So that's the special address. So this is what is given in Article 87 of the Constitution. So why it becomes relevant in the present context? Because 2 special addresses has been delivered by the President. After the Lok Sabha elections in June 2024, the President made a special address. And then during the budget session, before the budget session this year in 2025 February, the President made a special address. So within a span of 7 to 8 months, 2 special addresses has been made by the President. And there is a conventional practice. This is what is very important. So in this context, it was reported in the newspaper. So there's a conventional practice. So there is no mention of motion of thanks in the Constitution or in the rules, but a conventional practice is there that after the President delivers a special address, usually someone from the government or a member of parliament from the ruling party, they move a motion which is called as motion of thanks. They move a motion what is called as motion of thanks, and this motion of thanks is nothing but to thank the president for making such a special address on behalf of the government. And that's basically what is called as motion of thanks. So in this context, it was reported in the newspaper. In fact, it was moved by some of the members of the BJP party. Sometimes it may be moved by the ministers also. It will be decided by the Ministry of Parliamentary Affairs. So this motion of thanks was moved to thank the president, and whenever this motion is moved, then it is an opportunity for both the government and the opposition to criticize one another. In fact, there is no restriction as to what kind of speeches can be made during this particular motion of thanks. The opposition can make all the criticism allegation against the government, and the government can make all the allegations and criticism against the opposition. So this is exactly what will happen in the motion of thanks. After all the discussion is over, the motion will be put to vote in both the houses separately. In fact, the motion will be discussed in the Lok Sabha also, the motion will be discussed separately in the Rajya Sabha also, and then this motion will be put to vote. When this motion is put to vote, this motion has to be passed with simple majority. While the government will try to pass this motion, as the president has made the speech, while the opposition will try to bring in an amendment to this particular motion. So this time also the Congress tried to bring in, and the other opposition party tried to bring in some amendment. Amendment means they are not agreeing to what the president speech. So while the government would try to pass as it is, while the opposition will try to bring an amendment. But if the motion of thanks is passed, then the government is having the full majority because they are getting it passed. But if the motion of thanks is not passed, or if there is any amendment to the motion of thanks, then it is automatically deemed to be what is called as a no confidence motion against the government. There is no need for any separate no confidence motion. If the motion of thanks is not passed, it is automatically considered to be a no confidence motion, and therefore this is a basis on which the government has to resign. So it is very, very important, though not mentioned in the constitution, though not mentioned in the rules of the house, though motion of thanks is only a conventional practice and closely related to Article 87 of the Constitution, this motion of thanks has to be passed in the Lok Sabha. Otherwise, it would amount to defeat of the government, or in other words, there is a no confidence motion passed against the government. But however, if this motion of thanks is not passed or amended in the Rajya Sabha, it does not have any impact upon the government. It may bring in an element of embarrassment to the government, but it does not have any effect. I think in the last few years, whenever the motion of thanks is introduced in the Rajya Sabha, it was amended because the government does not have the majority in the Rajya Sabha, though they have a majority in the Lok Sabha, and there is no need to have majority in the Rajya Sabha. So therefore, if it is amended, it is a mere embarrassment to the government, nothing more than that. Okay. So here also you can expect a question, very, very important, because within a very short span, two motion of thanks, and these motion of thanks had heated arguments between the opposition and the ruling government. In fact, the Prime Minister has criticized the opposition party has criticized the Prime Minister and the other ministers. So therefore, in this context, it was reported in the newspaper. So therefore, it also becomes very important. So what type of questions may be asked? Whether motion of thanks is mentioned in the Constitution, what is the implication if the motion of thanks is not passed in the Lok Sabha? What is the article based on which the president makes a special address? So any of these things can be asked in the examination. All right. So whatever topic we have seen, I have picked the most important of those things. There are many topics, but I try to restrict the topics so that we don't look into a lot of things, and more things means more confusion. So that's why I'm trying to keep it very short. So with that, we are coming to the end of the legislature part as well. So in the next lecture, I'll start what is called as the judiciary part. So try to watch these lectures, and once you watch all these things, I'll do 100 questions that will help you to revise again all those things, but I'll do that separately. So with that, I'm winding this particular lecture. If you like this lecture, please share it with your friends who may be preparing for the Prelims 2025, which will be extremely useful to all those students who wanted to appear for Prelims 2025. And if you have any questions or any queries, you can reach out to me either through my Telegram channel or through my Instagram account. You can consider me as your friend, mentor, guide who can help you in clearing this examination. Thank you very much and all the very best.